There's a question that keeps coming up, especially now with the climate, the real estate climate, the way it is all over the country. You know what that question is? Can I keep the house? That happens to be probably one of the first questions people ask when they are even considering divorce. And it's a legitimate question. I understand why. The house represents so much, especially if you've been the primary caregiver for your kids their entire lives or most of their lives. You want that stability for them. So I'm going to take a look today, a discussion on the strategic truth that most people don't realize. Whether you keep the house has very little to do with how much you want it, and everything to do with the math, your leverage, and your long-term strategy. Stay tuned.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
So the first strategic question that you should ask, or you're likely to ask, is, do you actually want the house? Do I want this house? Because before we even talk about court, the equity in the house, or even negotiating it, you need to ask, do you really want it? Or do you not just want your spouse to have it? Because it sounds to a lot of people, again, especially because of this real estate climate, it sounds almost convenient. It sounds almost like the perfect solution. Let me keep the house. We're comfortable here. The kids' school's here. We know the area, the community. Not to mention moving somewhere else just sounds like impossible. But there are two very different motivations when you really want the house and you take all of that into consideration, or you just want to prevent the other spouse from having it, especially if there's been infidelity or inappropriate behavior or, wasteful spending, and it may involve the house in some way. You may just want to deprive the other party, your spouse, of having the house. I see this happen a lot, actually, very often. And particularly lately, I've been explaining to especially moms, especially stay-at-home moms, especially primary caregiver moms, that you can ask the judge to keep the house. There's nothing stopping you from asking for what you want. But whether you get it, whether you should get it, is something that you should be considering, and it should go beyond what's convenient for you, what's quote unquote the right thing to do for your children. It should go way beyond that. Because what happens often is people fight aggressively to keep the house, only to realize later that they can't afford it, that the costs are overwhelming, that the mortgage and the taxes are too high, there's too many painful memories. And what I see often is a lot of women, especially, who get spousal support or child support, rely on that to cover the expenses for the house. And as you may know or may not know, 90, and I'm using that number out, I'm pulling that out of the air, but it's somewhere close to 90% of child support or any financial support actually goes unpaid, either throughout the entire duration of the order, or a good portion of it, or some portion of it. It's seldom paid continuously, persistently, and at the rate it's supposed to be paid. And so if you're relying on that and the other party just happens to get demoted or unemployed or just decides, not to pay you anymore, and they do this for 3 or 4 months, and by the time you file something and see the judge, another 3 or 4 months go by, you're in foreclosure. You have your utilities turned off. You're scrambling to figure out what to do. So you have to keep that in mind. Just because you can keep the house, just because you want to keep the house, it's a sound decision to keep the house, doesn't mean you really should keep the house. And if the other party doesn't agree, then you have to be mindful of what the court in your jurisdiction is likely to do. Because I'm going to tell you where the court comes in at, the court's perspective. They don't care about your memories. The judge just does not care about the fact that you have memories, you have ties, that your children have ties and stability, not when there's conflict over what is to happen with the house. If the other party has been wasteful, has been the primary provider, has been consistently doing what they're supposed to do up until the divorce, then there's really no or very little leverage for you to use to encourage the judge to force them to just sit back and wait for their share of the marital home. If that other party makes a big deal about getting their portion of the equity, if there is equity, then judges are very inclined to allow them to do just that. It's in the instances where the other party has been found to have committed marital waste, which means spending money, marital funds, on things outside of the family and the marriage or anything, related, like mistresses or gambling or just gifting money to family and friends, unnecessarily or excessively. Then the judge can actually say, as remuneration to you, that you get the marital home. Again, there's so many factors to consider, but the court is more inclined to do what's fair, not just by you and not just, what you think is best for your kids. There's always the other party and their position that's going to weigh in. So if you're asking the judge for the house just because you want the house and the other party has really not been an ideal spouse, but have been pretty much following the rules and the court directives and haven't had any history of anything that's the judge finds minimizes their position or their credibility with respect to getting their fair share, then you're pretty much just wasting your time. Because right now, if the house that you're asking to keep has a substantial amount of equity and you're asking that the other party forgoes their share of the equity for a set period of time, or especially indefinitely, then you probably should think about something else you're willing to give up in exchange. Again, unless there's a situation where there's marital waste or financial abuse or something, and you pretty much would have to prove that. You pretty much would have to make a solid case for that, because just saying that and alleging that, and you have no documentation to prove that, it'll be your word against theirs. It'll be your testimony against theirs. And in that case, then the judge is going to have to find who they think is more credible. And then they're going to make a ruling that they find most logical to them. Not you, not the other party, but to them. And so it's a gamble. So if you want to avoid the gamble and you want to get the other party to agree to allow you to stay in the home, that's probably a better route in most scenarios, especially when it's you see litigation, more and more litigation coming down the pike just to address that specific issue. And you have, again, no real evidence. You have limited funds to actually litigate this issue, because if you litigate the issue, you have to pay an attorney, you have to do discovery, and that's going to be quite expensive and it's going to prolong things. So if you want a much simpler route, then you may want to forego something, sort of do a balance with respect to other equity or other assets that you might have that you're willing to forego, or even marital debt. So that's something to consider, because again, the judges don't care about memories. They do care to some degree about your children's stability, but it's a balancing act. They still have to weigh it against what the other party's interests are and what their concerns and their claims are. The other thing is the financial strategy. The financial strategy most people miss is the biggest issue when it comes to the house, and that's equity. The equity in the house, it doesn't go away. It doesn't get ignored, right? It may fluctuate because, the value of the home might change based on what's going on in the real estate market. But the equity at the time of filing, unless the judge or in your jurisdiction, they can use the time of separation, that's going to be pursuant to the rules. And if it's not clear, then it becomes a question of fact, and the judge gets to decide. But whatever that moment is, the equity at that moment is what the equity is going to be. So if you are asking to keep the house and there's $300,000 in equity, and your spouse is entitled to $150,000, and you're expecting them to forego that $150,000 for 3 years or 5 years, that's $150,000 that they could have done something else to either multiply that money or to pay off their own debt, or it could be used by them to do a myriad of things. And not to mention, they may lose some of that, because like I said, if the housing value decreases over the 5-year period you're asking to stay in the home, and so now that 150 is reduced to 125, should they really be the one to take that loss? These are things that you would talk to a CDFA about, because they're the ones who are going to help you crunch those numbers and actually think this through. But I just wanted to give you a basic overview of, can I keep the house, and what that actually means. Because people think it's just a one and some, deal, and it's not. There's so many factors that goes into that, especially if you don't get the other party to agree. Now, if you have some leverage where you could use to negotiate with the other party, like I said, and maybe, waive your interest in, their 401k or their IRA, or in some other assets that they may have, or you may forego, financial support, even child support, if your judge allows that. Some judges don't allow you to do that. But you may want to consider that. You should always do a cost-benefit analysis when you're talking about keeping the marital home, because of the equity, the loan that's still outstanding on it, the value, the probability of it increasing or decreasing, etc. So if you want to keep the house, you usually have to buy them out. You're usually going to have to buy them out. I actually met with someone recently. She's a CDFA, and she's also works for a mortgage lender. And we were talking a lot about this particular scenario. And she works with people to help them get in the position to make a better or more informed decision about keeping the house. And she has some great insight and some wisdom that I've never even thought of or heard of, but it's because of her nuanced background, where she does both, where she had some insight or some, she educated me on some things that I just wasn't aware of. So it's a great idea for you to get to meet with a CDFA and let them help you do crunch those numbers to see what's the best bet for you. The kid's perspective. So if you're going to ask to keep the house because the kid's going to stay in the home, you're assuming you're going to get primary custody, or you're assuming that you're going to get sole custody, physical custody. Because if you have 50-50 custody, then making your argument for staying in the marital home, it becomes a little diluted at that point. Because if they're going to spend 50% of the time with the other party, then, why wouldn't the other party be the one to keep the home? Or you can do I forgot what they call it. I don't know if it's nesting, where each parent takes turn in the home. The home isn't sold, but they rotate who stays in the home based on who has custody of the children, or who has visitation of the children. I'm sorry. And so that's not a bad idea, but that's not keeping it for yourself. That's just like choosing not to sell it. But because the reality is both parents are going to need housing, both parents are going to need affordable housing. And, if one party does not get 50-50, or if there's no 50-50 and one party does get sold, then yes, your argument for keeping the marital home is going to be stronger. But if the other party still gets some sort of visitation, then they may make an argument that they need something, the cash out to buy something or to afford rent, so that the kids will have something suitable when they're spending time with that parent. And if the judge does allow you to keep the house, it's usually when the kids are really small, really young, and it usually comes with conditions. It's usually for a set period. Years ago, they would say, some judges, I know particularly in New York, would allow the children to stay, the primary custodial parent to stay in the marital home until the youngest reaches the age of 18, of a majority, or graduates high school. That was when, there was 3% interest rates and houses didn't sit on the market and rents weren't as ridiculously high as they are now. Because the economics plays a huge factor, judges are more inclined to force a sale if one party wants the house and the other party just doesn't agree. And so if the judge does decide to let you keep the house, it usually comes with, again, a set period, a set time, 3 to 5 years, 2 years, a year. You have to refinance it within a set period. That's usually within 6 months to a year. And then you have to divide the equity up in the future at some future set time. And the equity, for how to determine the equity, is set forth, or should be set forth, at the time the judge orders or allows or consents to you keeping the marital home. Someone actually mentioned a few weeks ago that they fought for the home, got to keep the home, and they're going to wind up losing it now because they were relying on child support and alimony. The other party stopped paying. Because the home was still in that other party's name, and the custodial parent who got to keep the house couldn't afford it anymore, that other party took the custodial parent / housekeeper, that the parent that got to keep the house, to court to force a sale. The problem is they agreed. They actually came to a settlement agreement where she would keep the house, she would refinance it, and she would waive alimony in return. Well, guess what happened? When he took her to court to force the sale, the judge sided with him and said, yes, the house should be sold. So guess what happened? She lost out on the alimony. So not only will she be losing the home, she doesn't get alimony either, because she waived alimony in return for keeping the house. And she had an attorney. They didn't think that one through. So when I suggested to her that she go and file a motion to revisit the alimony, it was only until I mentioned that did she go ahead and actually get her attorney to file to have the alimony revisited based on that specific issue, that caveat. Because, if you're going to negotiate, you should not be negotiating blindly. You should always think about the worst case scenario of what might happen, especially when you're negotiating. Negotiating is not just coming to terms, it should always include provisions and clauses in your MSA of what should happen in the event that something isn't followed through or carried through. It's always a great idea to have a CDFA working with you when you're talking about numbers, when you're talking about assets, when you're talking about debt, when you're talking about finances. Because especially if you have specific issues with taking on the house and wanting to assume the mortgage or refinancing, you need to know all of that beforehand. Some people are so desperate that they want to resolve everything, or they want to get the asset, but they don't think about the consequences of what happens when that asset is taken away, or, in any form, really, because the house could have burned down. The house could have been, anything could have happened. Anything could have happened. So when you're going to negotiate, just negotiate with the information. Do as much research, or have your team, your lawyer, your CDFA, myself. Let us do the work. Let's walk through every scenario so that you're not negotiating blindly. And I see it happen all the time. What happened to that woman that I just mentioned, really something that should have been avoided. It should have been avoided had they negotiated and had she been informed properly. Somebody obviously dropped the ball with that one. And so if you're going to negotiate, you should use the house as a negotiation tool. So you can negotiate alimony, other assets, but you can also negotiate custody arrangements based on it, especially because it's the house, especially it's because the kids are going to be at the house, living at the house. You can negotiate how the house is going to be used. Yes, how the house is going to be used. Yes, you can actually include that. How much you're going to waive once it's sold. You can negotiate, use the house itself and how it applies to every aspect of your divorce. Of course, not to the detriment of everything else, because you still have to keep in mind if custody is an issue, child support, financial support, debt, attorney's fees, you name it, the list goes on. So instead of you asking, can I keep the house? A better question to ask is, what outcome involving the house puts me in the strongest long-term financial position? Not just financial, but personal and practical position as well. Because if you lose the house and you don't have alimony, where are you going to live with your kids? If you don't have any place to live, will the other party be able to go back to court and get a modification of custody because you are not stable? You don't have a stable place for them to live. I'm sure you didn't think about that. Sometimes it's better to just sell the house, sever your ties with it, start fresh. I often tell people that. Just start fresh. I get it, when your kids are young, they're used to it, but the younger they are, the more resilient they are. They'll get over it. The sooner you get into someplace new, the sooner they can get adapted to that new place. So, that's it. That's all I have for you today. Hopefully, this was helpful to you or somebody you know. If you want help deciding what to do or working out the terms of a negotiation with respect to keeping the house, please feel free to reach out to me. We can hash this whole thing out in an hour. You can provide all the documents. We can actually get a CDFA. I have quite a few in my Rolodex. Who still uses Rolodex, Tracey? I know that's what you're saying. But we can really hash this out. We can be sure to cover every strategic position that's going to affect your future. If that's what you want to do, feel free to schedule a strategy session. The link is in the show notes. Until next time, take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.